Here to help us break it all down is Dave Aronberg, the state attorney for Palm Beach County in Florida and a former assistant attorney general, and also Sara Azari, a criminal trial attorney and NewsNation legal analyst. She is also the host of the crime podcast, The Presumption, available on all podcast platforms and also YouTube. Dave and Sara, thank you so much for being with us. Sara, I want to ask you first, because this seemed to be like what everybody was talking about on Twitter today and on social media. They were very confused why Kohberger was in the suit and he was not in the orange jumpsuit. And that seemed to bother some people, Sara. There was no jury there. Why did he get to wear the suit?
Well, and I was confused why they were confused. Pretrial detainees typically show up to court in their jail uniform. Obviously, that's kind of the norm. But first of all, this is not a typical case. All eyes are on Kohberger. For all intents and purposes, we already have a jury watching him. And it really is to humanize him. And this is not, the only case this is done in. It was done in OJ, the Ahmaud Arbery defendants, Nicholas Cruz. I mean, there's a whole list of defendants who were able to do this. And there really isn't a law that is for or against it. It's not about law. It's about logistics. You ask the judge for an order to the jail facility, and then they accommodate the street clothing for the defendant. But it really is, it goes to his presumption of innocence. He has not been convicted, although we've convicted him in the court of public opinion. And he absolutely can wear street clothing. So I was confused why they were confused.
I guess it makes sense, Dave. I mean, it does bother some people, though. Here he is accused of these murders, and he's in the suit, and he doesn't have handcuffs on. And again, I get when there's a jury there, because when they're sitting there, you don't want them to view him as a bad guy, innocent until proven guilty. But were you surprised he got to wear the suit, Dave?
No, the benefit always seems to go to the defendant. And if he wants to wear the suit, they're going to let him wear the suit. And remember, even though there's no jury, there is a jury pool out there that hasn't been decided yet. And those members of the jury pool may be watching. And so they're playing the long game. They're going to try to show what a decent-looking guy. Although I got to tell you, Bryan and Sara, in that suit, I thought he bore a striking resemblance to Ted Bundy. Not a guy you want to be compared to.
God.
Yeah, a lot of people were zeroing in on him today and just saying that he looked sort of creepy. I think that's what the judge is concerned about, why they don't want the really tight shots. I want to ask you, Dave, about this genetic genealogy. That was a big topic today. The defense claiming that it's unfair, the way it was handled was unfair. That's ultimately what led police to Bryan Kohberger. What do you make of it? Do you think that could really be an issue, Dave? Do you think it's going to be an issue for prosecutors?
Bryan, the reason why the police were able to make an arrest was because they got his DNA from the sheath that they then tested at the garbage of his father in Pennsylvania. Now, in between was the genealogical DNA. And so the theory, I think, for the defense is, hey, you would not have been able to get to that arrest if you didn't have the lead, the tip that genealogical database gave you. But okay, so if this type of stuff is used all the time, are you trying to say, defense lawyers, that it should be suppressed because why? Because maybe Kohberger's relative did not want police to access the database because you have to check a box. Even if that were the case, and we don't know who this relative is, and we don't know what privacy settings the relative put on his 23andMe or whatever database he used, but even if that were the case, does Kohberger have a right to object to his third cousin's DNA? Does he have a right to get that suppressed? That's not his DNA. That's his third cousin's DNA. I don't think he has a right under the Fourth Amendment to ask for a suppression on the exclusionary rule. So in my mind, it doesn't matter. In the end, they have the swab of his cheek, which shows he was a match. So that's why I say he's guilty, and the DNA stuff from the genealogical database shouldn't matter that much.
But Sara, if they decide that there is something shady with this genetic genealogy and the practices behind it, could they throw all the DNA out? Could they throw everything out because it all began with this genetic genealogy?
Well, yeah, because without the SNP profile, which is part of the IGG work, which then goes into the FBI's work and the family tree, there would be no SDR analysis. And so the two are very, very much interconnected, even though the prosecution, like Dave, is trying to divorce the two. And in fact, even saying IgG is not even science, but DNA is. And so in this case, they're very much related. And I think the defense has done a really good job, including today, putting on these various DNA and IgG witnesses on the stand to really show the process, the complexity and of all of this. It's, I think the prosecution wants us to just accept that DNA is this ironclad science with no flaws and absolutely reliable. And the defense is coming in, like they did with their experts, showing that no, it's actually complex and complicated.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.